So in this PowerPoint, we want to deal with the question of First Amendment rights from topic number 5 in our course. And by way of overview, Amendment number 1, remember, is part of the Bill of Rights. And it says very specifically, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for redress of grievances. A couple things I want to point out about this First Amendment is that the first 5 words of this amendment are critical. Congress shall make no law. Remember the context of the Bill of Rights, which was to restrict the national government in key areas that the states were concerned that the national government would get involved in because the Constitution itself didn't restrict them in these areas. So they wanted a guarantee. Those that wanted a more limited government wanted a guarantee that the Congress would not get involved in issues such as religion, freedom of speech, freedom of the press, people assembling, petitioning the government. They did not want the government to be able to stop people from doing these things. They didn't want the government to have anything to say, the national government to have anything to do with these things. Again, those first 5 words, Congress shall make no law. That is the context of the Bill of Rights. That is the context of the First Amendment. Now, we know from our previous conversation that the 14th Amendment changed all of this. It effectively nationalized the Bill of Rights, and it gave Congress the opportunity to, instead of being limited by the wording of the First Amendment, to be empowered to actually enforce this amendment in the states, to actually have power over the states and become the decider of, well, what does freedom of speech look like? What does freedom of religion look like? And I think you'll find it very interesting as we look through these notes and talk through these notes, exactly where the government of the national government has ended up on these questions. So we're going to look at freedom of religion, freedom of speech, and freedom of the press. And we're going to notice that the government does not take the same tactic in all 3 areas, that the government is going to be far-reaching into freedom of religion, have a lot to say about that, but be reasonably constrained when it comes to freedom of speech and freedom of the press, which is very interesting. But first of all, we're looking at freedom of religion, and we're going to look issue by issue. The first issue we're going to look at is school prayer. Court case Engel versus Vitale in the 1960s involved a New York Board of Regents. The New York Board of Regents had composed a non-denominational prayer that read as follows: Almighty God, we acknowledge our dependence on Thee. We beg Thy blessing upon us, our parents, our teachers, and our country. It's very simple, very straightforward prayer. The prayer was voluntary. No one was compelled to pray in the schools, but in the public schools in New York, this was the prayer that was recited at the beginning of the school day. Some parents filed a lawsuit against the school district claiming that this prayer violated the Establishment Clause of the First Amendment. Now, when we say establishment, you remember back to the first slide where we talked about Congress shall make no law. There are 2 phrases there, respecting the establishment of religion or the free exercise, prohibiting the free exercise thereof. So basically, the argument the parents made in Engel versus Vitale was that their children were going to a place that was violating the First Amendment because this school was establishing a religious idea. Now, there's a couple things I think are very important to understand in this. We'll look at the ruling and we'll come to terms with it. So the Supreme Court heard the case, and they ruled in favor of the parents, basically on this basis. The first thing they said is prayer is a religious act. Then they said that the government may not compose prayers for anyone. And this is what is a critical part of this conversation. The government, according to the Supreme Court and according to these parents that filed the lawsuit, is the same as the school. And that's something I think we need to really stop and think about. Is the school government? And most people would argue, well, if they're going to make that argument that the school is government, they're going to argue that the school is government because it receives tax money or taxpayer funding. So the school is government, and and because it's government, it's not allowed to establish any sort of religious actions or prayers for anybody. And that then the prayer is a violation of the Establishment Clause. So I want to go back to this government and school thing. If the measure of whether or not an institution is government is based on whether they receive taxpayer money, think about the fact that we have hospitals that receive all kinds of taxpayer insurance money, but hospitals have chaplains. Are hospitals government? That's an interesting question, isn't it? What about all of the other businesses that get subsidies from the government? We've seen already that the government, we're going to see later that the government itself, the national government actually itself participates in religious activities, which is odd considering this ruling. But this ruling is critical to understand. They decided that the school is government and government can't establish any kind of religion. And so the national government came in and made a sweeping decision that basically, through this Engel Vital decision, made it illegal for there to be prayer in public schools throughout the nation. So millions and millions of children. We made our schools into secular environments. I've often said that children spend about 1,000 hours a year in school, and if you think about that, that time now is secularized. And what's interesting is this is in communities. There are some communities where almost everybody in that community has a particular religious belief, and that cannot be intertwined into the education that local community is providing to its children because the Supreme Court of the United States has made this decision. So very interesting thing to think about and to discuss. There's a follow-up case, Abington Township School District versus Schempp, that is another school prayer case. The state of Pennsylvania required that students recite 10 verses from the Bible at the beginning of each school day. Abington Township School District required students to also recite the Lord's Prayer. Students could be exempted from doing this if they had a note from their parents. So the Supreme Court decided that school requiring Bible reading and prayer is unconstitutional under the Establishment Clause, same basic reasoning. And then they added this, that there needs to be that they added what's called the secular purpose and primary effect test. In other words, how are we going to test the rest of these decisions or laws or things that people might do with regard to the Establishment Clause? Well, the school requiring Bible reading and prayer was unconstitutional under the Establishment Clause. The secular purpose and primary effect test said that the law in question must have a secular purpose, and its primary effect must not be to promote or inhibit a particular religion. So that's a more specific wording there. It has to have a secular purpose, and its primary effect cannot be to promote or inhibit a particular religion. So moving on to teaching evolution in schools. Another question was about the teaching of evolution. The Epperson, Arkansas case dealt with that issue. Since the 1920s, states have been passing laws prohibiting the teaching of evolution. Evolution had been taught in schools since the late 1800s, mostly alongside of conversations about other things. And remember, there's at that time in our history, you could pray in school, you could talk about God, you could also teach evolution. But by the 1920s, many people decided that they didn't want evolution taught in their public schools. And so states had been passing laws prohibiting teaching evolution. A woman, a teacher named Susan Epperson, uh, a high school teacher, challenged the law in the state of Arkansas. The Supreme Court declared that Arkansas law unconstitutional based on, again, the Establishment Clause. And they argued that government must maintain a position of neutrality in religious matters. The government must maintain a position of neutrality in all religious matters. Again, we'll kind of see how that works out in our conversation as we go forward in this PowerPoint. Edwards versus Aguilera, another teaching evolution case. What happened was once they lost the ability to ban the teaching of evolution, those that wanted a conversation that involved creation to be part of our public school system began to argue that we want equal time or balanced treatment. They tried to pass laws that mandated the teaching of both creation science and evolution side by side. The Supreme Court looked at those laws and declared them unconstitutional. And they said that the reason was that creation science has as its primary purpose the advancement of a religious viewpoint. Back to the phrasing that we used earlier. Currently, creationists are trying to argue for teaching intelligent design, taking a kind of less religious bent towards it, but trying to get into the conversation that that the world did not come into being just by chance. So that's an interesting twist on that. The last area where the government's got involved with regard to freedom of religion is in religious displays. In Van Orden versus Perry, Texas, state of Texas, displayed the Ten Commandments with a number of other displays of various religious themes on state property. The court ruled that this was not a violation of the Establishment Clause, that it was okay because there were multiple religious ideas represented. McCreary County, Kentucky versus ACLU, another court case, Kentucky counties had posted the Ten Commandments just by themselves. The court ruled that this is a violation of the Establishment Clause because the display had only one purpose, the endorsement of a particular religious idea. So the Supreme Court has decided that when it comes to religious displays on the property of the state or local government, that as long as there are multiple things represented, it's okay. But if there are just one idea represented, it's unconstitutional. It's establishing religion. I think it's very interesting. I've thought many times, if you're driving, the idea is that a religion has been established. And I just want to press on this a little bit. So if you drive by your local county courthouse and there is a Jewish display or a Christian display there, I find it hard to believe that that's establishing a religion. That as you drive by, that somehow your whole community now is forced to be Christian or Jewish or Muslim for that matter. I think that's interesting to think in terms of of that sort of thing. Um, and so now what you can do is you can put a religious display up, but you just have to put a bunch of other things up. And one of the things that I would just say in this whole religious conversation here on freedom of religion is that what we have done now is we have positioned ourselves so that a small group of people who believe in anything now have to have what they believe put alongside of everybody else. And I've thought about this in my own self and my own views. And I'm a Christian. I have a Christian viewpoint. But I thought about, well, what if I lived in a community that was overwhelmingly Jewish? Would I be offended if there was a conversation about Judaism in the local public schools? And I think no. I think that If you choose to live in a place that's overwhelmingly Jewish or even overwhelmingly Muslim, you would have to say to your children, you're going to go to school and you're going to have conversations because we live in a Jewish community. And you're going to hear things, and we don't exactly believe these things, but it's okay to hear them. It doesn't violate our right to believe what we want to believe, but it's okay to hear them and see some of these things in school and be introduced to them, as long as you're not compelled to do anything. And I think we've gotten far away from that now, so that now not only is somebody offended if they hear something that's not from their religious viewpoint, if their children hear something that's not their religious viewpoint at school, it can't be heard by anybody. So we're offended by that. And we can't even drive by the courthouse and see something that represents something that we don't believe in and not be offended by that. And I think that we would be better off, and again, this is opinion, but I think we'd be better off if we lived in a world where we could say it's all right to hear things. Most of our neighbors think this. It's okay for us to hear this as long as they don't make us do anything. I think that would make us a better society, rather than flipping the conversation and saying, "Well, I demand that no one talk about anything that offends me in any way." I think that's kind of where we've gone in our society, and it's kind of dangerous. So there's kind of some interesting things to think about. But the government's gone completely the other way and decided that protecting freedom of religion is to protect us from hearing anything that we don't want to hear. And I would suggest that maybe if we localize this conversation, people could make decisions about where they lived. But they could also make decisions about, well, it's okay for our kids to hear things, as long as we're not made to do anything. So, anyway, just think about that and think about how you feel about that. Freedom of speech. Brandenburg versus Ohio. This was a hate speech case. The court ruled that mere advocacy is protected and cannot be punished. In other words, if you just say something hateful, you're okay. If you incite or produce imminent lawless action, then that can be restricted. You can be punished for that. Um, if you advocate something that produces imminent lawless action, then that's different. But if you just advocate something, just hateful, just say something hateful, that's protected. So the freedom of speech, comparatively to the freedom of religion, the government not taking such an aggressive tone with that, which is interesting. Another interesting freedom of speech case is Miller versus California, having to do with obscenity laws, in which the court established a three-part test for obscenity. The first part said that whether the average person applying contemporary community standards, and the key word there is community, would find that the work taken as a whole appeals to the prurient interest. Secondly, that whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law. And thirdly, whether the work taken as a whole lacks serious literary, political, or scientific value. And what's really interesting here is that this word community, and how that in the case of Miller versus California, the Supreme Court argued that obscenity really has to do with what is obscene has to do with community standards. And the community has the ability to set standards and to make determination as to what is and what is not obscene in their community. That's a very interesting application of federalism, allowing local communities to decide for themselves rather than having the national government come in and mandate for everyone what is obscene or not obscene. And the interesting dichotomy here is that, as we have seen with regard to religion, and with regard to religious expression, the Supreme Court came in and said, no, you can't pray in school. No, you can't put a religious display on public property, and said that the national government has the right to determine what those expressions look like from the religious perspective, on religious issues. But when it comes to obscenity, local communities do have a right to determine their own standards. A very interesting difference in approach to these two issues. The last one is Texas versus Johnson with regard to freedom of speech. This is the flag burning case. The court ruled that it's okay to burn the flag. It's protected because of the need to protect freedom of expression. So you can burn the flag, and that's protected, again, based on this court ruling, Texas versus Johnson. Moving on to freedom of the press. In New York Times versus Sullivan, someone took an ad in the newspaper which made false claims against the police. The court ruled that even false statements against public officials would sometimes be protected as long as they were made in good faith. So, in other words, if you made a false statement and you thought it was true against a public official in the newspaper, you are protected because you thought the statement was true. You made it in good faith. In New York Times versus the United States, President Nixon wanted to stop publication of the Pentagon Papers because he said they posed a national security risk. And the court ruled that national security does not give the right to what they call prior restraint of speech. In other words, to say ahead of time, you can't put that out there because it might do this or might cause this problem. They said, no, you can't do that. They ruled that you can't, national security does not give the right to prior restraint of speech. So again, a kind of freedom of speech, freedom of the press type of thing. And look how the courts have ruled here, basically putting very little restriction on freedom of the press and on what people can put in the papers, putting very little restriction on freedom of speech, but putting massive restriction on religious questions. So, in conclusion, as we look at what's happened with First Amendment rights as a result of, and I just want to remind you that these 5 words, Congress shall make no law, have been flipped by the 14th Amendment to make Congress the enforcer of the Bill of Rights now, rather than being restricted to get involved in these questions. Now they are heavily involved in these questions. So let's just summarize. The national government now prohibits school prayer, Bible reading, teaching creation science in local public schools. It prohibits state and local governments from having only one religious display on government property. They have to have multiple religious displays for their religious displays. So the government is intensely involved in what we do in our schools when it comes to religion, what types of religious displays we put in our local communities, on the courthouse lawn, or in our state buildings or state government areas. But then, ironically, the national government does not restrict itself in the same way. I find this to be fascinating. For example, at Prince In God We Trust on our money, the president takes his oath of office with his hand on the Bible. The Senate and House have chaplains. We don't allow our schools, our public schools, to have chaplains, but the Senate and the House of Representatives have chaplains. There's prayer in Congress and at presidential inaugurations, but we're not allowed to have prayer in public schools. The 10 Commandments hangs on the wall in the Supreme Court building. We can't hang the 10 Commandments in other places in our state and local communities. So I think that's fascinating. By themselves, we can't do that. But I think that's fascinating to see that irony, that inconsistency between what the national government, now being the enforcer of the Bill of Rights, has said we can do in our communities with regard to religion, but doesn't abide by those same rules for themselves. And then on the flip side, we have the national government allows hate speech, flag burning, and it lets local communities set their own obscenity standards. So I guess I would conclude this conversation by saying this. No matter how you feel about these issues, which side you would be on, I think the key thing to notice here is that we are not consistent. There's no way you can argue that we are consistent when it comes to these, to how we're dealing with First Amendment rights in our country. We're all over the place now. And I think that's what the founding fathers were concerned about. That's why the founding fathers didn't make the national government the enforcer of the Bill of Rights. That's why the founding fathers restricted the national government with the Bill of Rights and didn't want them to have anything to do with freedom of religion. They didn't want them to have anything to do with religion or the press or speech. They wanted that to be handled by others, and they wanted to simply keep the national government out of this question. I would again close by saying with the 14th Amendment, again, I've talked about this before, 14th Amendment, a good thing with some bad consequences. I think we have to start to understand that and figure out how to deal with those things. There's many things the government could do that are good. They have very, very bad consequences, and we have to begin to think and make decisions based on understanding that sort of thing, that a good thing can have very, very bad consequences in other areas.